Hello, everyone. My name is Erin Bury. I'm the co-founder and CEO at Willful, and I'm excited to be here today talking to you about making a will in Quebec and what you need to know if you're going through that process. Now, I know what you're thinking. How exciting is this topic of making a will? Now, I know that it might not be a topic you've thought a lot about, but if you're here watching this, first of all, kudos. It means that you're taking steps to learn about this important document. And I promise I will try to make this session as engaging as possible and to leave you with some really tangible takeaways that can help you to finalize your will and feel more empowered about your end of life plans. So I thought I'd start with sharing a little about the Willful story. So really, like a lot of great businesses, Willful was inspired by a personal experience. So I am not an estate lawyer by background, nor a notary. And I should highlight that nothing that I'm going to communicate today can be construed as legal advice. I'm going to provide some legal information for you today, but no legal advice. My background is marketing and technology and entrepreneurship. And it was really when my husband, Kevin, pictured here with me, lost a loved one unexpectedly, that the idea for Willful began to form. When Kevin's uncle passed away, he had never discussed a lot of the key end-of-life decisions with his wife of 40 years or with his loved ones. And so we were left scrambling with questions like, would this person want to be buried or cremated? What type of ceremony would they have wanted? And where do they store the important paperwork like the will that's going to help us when we're settling up their life? And as we were sitting around kind of debating and arguing with family members about this, Kevin thought to himself, there has to be a better way. We're all going to pass away at one point. It's one of those inevitabilities in life, like taxes. And yet we do pretty much anything we can to avoid thinking about our own mortality. What if I could take the same, user friendliness and, simplicity of a lot of the tech tools that we use in our everyday life and apply that to end of life planning? Could we actually remove a lot of the barriers and empower more Canadians to get this important document in place? So that was really the impetus behind Willful and what got us started on this path. And then we started looking deeper into the problem, and we found out that the majority of people actually haven't taken steps to put a plan in place. In Quebec specifically, about 43% of Quebec residents have not created a will. And of those who have, about 1 in 10 wills are out of date because the person has gone through a major life change. And I'll speak a bit later about what might motivate you to want to update a will. But it's not just the average person in Quebec or the rest of Canada who doesn't have a will. We hear stories all the time about prominent celebrities like Aretha Franklin, Chadwick Boseman, Prince, and Amy Winehouse, who passed away without having a will in place. And these people arguably should have been more likely to have a will because they have not only the resources to hire the best lawyers in the business, but they also had really, really massive fortunes. But the reasons that people shy away from getting a will are the same, no matter what the size of your estate. In fact, we always hear people say things like, I know I need a will, but I don't have time. I know I need a will, but I've been procrastinating. It's easy to put off because I feel like I'm going to live to be 100. I know I need a will, but I don't want to go to a lawyer or a notary's office in person. And also, if I do that, it's really, really expensive and I just don't want to spend the money. I know I need a will, but I don't know where to start. We found, especially with our research in Quebec, that Quebecers have a lower level of general knowledge about wills, despite being more likely to have a will. The stat across Canada is 57% of Canadian adults don't have a will. Only 43% of people don't have a will in Quebec. So you're actually doing a little bit better than the rest of Canada. But we found in doing user research and talking to tons of folks in Quebec that there's not a lot of awareness around the different types of wills and the different methodologies, which is good because that's what I'm here today to lay out. But it means that a lot of people just don't know where to start on their journey. I know I need a will, but my family would get everything anyways, right? This is one of my favorites, and I'm going to talk in a little bit about how that's a bit of a misconception. I know I need a will, but actually, I'll be gone, so what do I care? And yes, I do have people say this to me all the time. I know I need a will, but I don't want to think about death. That's depressing. But ultimately, at the end of the day, there is no excuse not to have a will. This is such an important document, not for you, but for the family that you leave behind. And it's one of the best gifts that you can give people to have these plans in place. So I'll tell you a little bit about Willful and our offering in Quebec, and then I'll get into the basics of creating a will, the different methods that you can use to create one, and some of the key decisions that you're going to have to make when you sit down to actually get it done. So with Willful, we've tried to make making a will as easy as ordering an Uber, booking a hotel room or an Airbnb, or ordering takeout on your favorite app. It's the easiest way to create a legal will online in less than 20 minutes. And yes, it really does take less than 20 minutes, as long as you know the answers to some of the key decisions that we're going to go through today. So how does Willful actually work? Well, we are not estate lawyers ourselves, but rather we partner with estate lawyers in each of our active provinces. You can think of Willful as the TurboTax for estate planning. We guide you through a series of questions about your unique life situation, and we pull your answers into a customized set of documents that reflect where you are in your life. And we give you instructions on how to execute those documents to make sure that they're legally valid in Quebec. In Quebec, we work with an amazing law firm called Spiegel Summer, and they've drafted all of our legal content from the ground up. Because you have a different legal system in Quebec than the rest of Canada, we didn't just adapt our documents from other provinces. We started from scratch, and Spiegel Summer helped us to build this fantastic set of documents that are, kept up to date as legislation changes in Quebec. So you know that you have, one of the top law firms in the province drafting and reviewing all of that legal content on an ongoing basis. And our pricing is much more friendly than the typical law firm or notary. So with Willful, we offer our basic package, which is $99 for a will. And then we offer a notarial will, which is $349. And that includes execution by our partner notary. I'll explain the difference between the two a little bit later, but suffice to say that it's a lot more affordable, especially because our packages include free updates in future, which means that you're not going to pay out of pocket in future as your life changes. In terms of the trust factor with Willful, we've been around for about 4 years. We've created almost 100,000 documents for customers across 8 provinces. In Quebec, we do have a fully bilingual platform. So I'm delivering this presentation in English today, but we do have a completely French website and experience. And you can choose to print your documents in either or access your documents in either French or English. And you can also check out all of our reviews on Google or Trustpilot, and you'll see that we have really high ratings and some great feedback from our customers to date. So that's Willful. Hopefully you will check it out. We also have a 30-day money-back guarantee. So if you do take a chance and create your will online and you change your mind, there's really no downside, as you can get your money back at any time. So enough about Willful. Now I'm going to go into the basics of making a will in Quebec. So first, what the heck is a will? Well, a will is a simple legal document that says who's going to get your assets and who's going to take care of your dependents, from whether minor children or pets, when you pass away. So it's not actually that complex of a document. It's typically about 8 to 10 pages, depending on, the type of will that you get and your wishes. And it's definitely written in legalese, but the decisions that you're making to go into it are pretty simple. So why do I need a will then? Well, you need a will because it's not really about you. It's about your family. Think about life insurance. You don't purchase life insurance because it ever benefits you. By definition, you have to pass away for your family to see $1 of that life insurance policy. But you get life insurance because you want to protect and provide for your family. The reason you want to have a will is the exact same. It's really a blueprint that guides your family after you pass away, that tells them where you want your assets to go, who you want to take care of, the important people and pets in your life, who you want to act on your behalf as your liquidator to wrap up your life. It's really just, giving you a voice after you're gone and empowering your family to feel like they're making decisions that will do right by your legacy. It also just removes a lot of guesswork and arguing, because if you don't lay those decisions out clearly in a document like a will, then your family is going to have to sit around and argue and debate and just guess at what you would have wanted, which is exactly what we found we were doing with Kevin's family. If you pass away without a will, it's also just going to extend the amount of time that it takes to wrap up your life. There's going to be more court processes and forms and all of these applications, and it's just going to drag out what is already a pretty lengthy process. And if you pass away without a will, there's a government formula in Quebec that distributes your assets to your dependents. So let's say, for example, you pass away without a will. A lot of people say to me, well, it doesn't matter because it would just go to my family anyways, or it would just go to my spouse anyways. But in Quebec, there's a specific formula that says, here's what should go to spouses, here's what should go to kids. If you don't have spouses or children, it moves down the list to parents or siblings, aunts and uncles. And if you have no living heirs, that money is going to go to the government, which you definitely don't want. So I encourage you, if you aren't going to get a will, to look up that government formula to make sure it matches what you would actually want, because many times it doesn't. In Quebec, there is a major reason you should have a will if you are in a common law relationship or you expect to be in the future. In Quebec, common law spouses have no rights to anything in their partner's estate if they pass away without a will. There's a famous case of a billionaire in Quebec who was married for decades. And when he passed away, he didn't have a will. His common law spouse of over 30 years went all the way to the Supreme Court to say, hey, I should get some of this fortune because I've been his common law spouse for decades. And the Supreme Court said, common law spouses have no rights to any of their partner's assets without a will. And so the partner was left with nothing. So it's even more important in Quebec than other provinces to have a will if you are in a common law relationship, because then you can account for leaving things to your common law spouse because they won't have a right to anything otherwise. Finally, without a will, the courts are going to have to appoint a tutor for your children, and your heirs are going to have to appoint a liquidator to wrap up your estate, or one of them is going to volunteer to do it. And it may not be the person or people that you would have chosen. So again, having a will just puts you in charge of that decision instead of leaving it up to other people. So then the question becomes, well, when do I need a will? And this is one that I hear all the time. Well, I don't need a will because I'm not old. I don't need a will because I don't have a lot of money. Well, you really should have a will if you have any sort of assets to your name or anyone that relies on you, from a spouse to a child to a pet. So some of the most common inflection points to get a will include buying a large asset like a home, getting married, getting into a common law relationship, as I just mentioned, getting separated or divorced, starting a business, getting a pet, having a child. These are all really important inflection points where you would likely want to think about creating a will. So then I know what you're going to say next, which is, wait, don't I have to go to a lawyer or a notary to create my will? And the answer is no. You may absolutely choose to, and that might be the best option for you. My goal today is to give you all of the options that you can choose from, and then you can actually decide what makes the most sense based on your life situation and your budget. But in Quebec, there is nothing that says that you have to use a lawyer or a notary to create your will. For a will to be legal in Quebec, it must be written by you. So you cannot create a will on behalf of someone else, and they cannot create a will for you. You have to have the mental capacity to understand the implications of the will and the contents of it. And unless you are creating a notarial will online, which I'll get to in a little bit, a will must be signed on paper in front of two witnesses who also sign the will. That is what makes a will legal in Quebec. It has nothing to do with who prepares it and everything to do with how it's prepared. So now I'll go through the 4 main methods that you can choose to create your will. And I want to stress that all of them are exactly as legal as the others. So if you decide to create a handwritten will, it's exactly as legal as going to a lawyer to create it. But I'll talk about some of the pros and cons of each method as we go through. So the first way to create a will in Quebec is what's called a holograph will. And this is essentially a handwritten will. It's you taking a pen and putting it to paper and writing down your wishes. It is the only type of will that does not require any witnesses. So you can actually take a pen, write your will on a piece of paper. It has to be 100% in your handwriting. You can't type it up on Microsoft Word and then print it out and sign it. But you can write that will on a piece of paper. You can sign it at the end. And there you go. You have a legally valid will without any need to get together with witnesses. The plus side here is that it's free to create other than the piece of paper that you're writing it on. The downside is that if you don't know much about estate planning, you may not know what to write, and therefore the will may not be as comprehensive as it should be. So for example, a lot of people will write things like, I leave everything to my spouse, but they'll forget to appoint a liquidator or a tutor for minor children. They'll forget to appoint a backup beneficiary or legatee so that, if their legatee passes away, there's someone else who can receive their assets. So if you are going to create a holograph will, then just make sure that you're being as comprehensive as possible and do your research to make sure that your will covers all of your bases. One of the most famous examples of a holograph will in Canada is a case in Saskatchewan where a man wrote his will on a McDonald's napkin while he was dining in. I don't know what made him think of, writing a will while he was eating his Big Mac. Maybe his life flashed before his eyes because of those saturated fats, but that napkin will was upheld in court as legally valid because it was written by him, it was 100% in his handwriting, it was signed by him, and it reflected his intentions. So this is a great example of how when it comes to holograph wills, it's not the medium that matters, it's the message. The next option you have for creating a will in Quebec is a paper will kit or downloadable forms that you might find on a government website or somewhere else online. These are essentially fill in the blank forms that are very much one size fits all, but essentially you're going to fill them out like this person is doing here by filling in the blanks. And as long as you execute it, as I highlighted earlier, you sign it, you have witnesses sign it, it's a legally valid will. So the plus side is it's very affordable, about $20 to $40 for the type of will kit that you might get at Jean Coutu or Staples. But it's not going to be extremely customized to your life situation because it is fill in the blanks. It's very much one size fits all. And it might, we often hear that these types of wills are not executed properly because people don't follow the signing and witnessing instructions to a T. So if you are going to go this route, just make sure that you do follow the instructions really clearly to make sure that you execute the will properly. The next option to create a will is to use an online platform like Willful. We are not the only platform out there, but we are the only platform that offers a fully digital notarial will in Quebec. And I'll talk about that in a moment. So again, with Willful, the benefits are affordability, convenience of being able to do it online, but we're not going to be able to give you legal advice like a lawyer or a notary would, and we're not going to be able to add the level of customization that you might require in your life situation because, while we're much more customized than a paper will kit, because if you come to Willful and you have pets and children, you're going to get a very different set of questions and resulting documents than if you don't have pets or children. We can't add every kind of custom clause or wish that you have just because our platform has limitations. So that's an online platform. And then finally, a lawyer or notary. So with a lawyer or notary, you're going to pay the most amount of money, but you're also going to get the most comprehensive document. They can add any level of customization that you'd like, and you're going to be able to get legal advice that's specific to your life situation. And for a lot of people, having the comfort of getting one-on-one legal advice is very important to them. So I want to go over a very important distinction with wills in Quebec. In Quebec, you have this unique product called a notarial will, which doesn't exist anywhere else in Canada. So what is a notarial will? Well, a notarial will is the most common type of will in Quebec. It is the only type of will that avoids probate. Probate is the process of a will being formally approved by the courts and the courts giving the liquidator power to act out the wishes in that will. If you have a notarial will in Quebec, a will that is executed by a notary and registered with the Chambre de Notaire, you can avoid probate when you pass away, which saves your family or whoever's going to be executing that will a lot of time, energy, money, and hassle. So it's typically a little bit more expensive to create upfront now, but you're saving your family having to go through probate when you pass away. Whereas if you create a will that is not a notarial will, it's called what's called a will in front of witnesses. As I described earlier, it's a will that you would, have on paper, you would sign in front of witnesses. That's totally a viable option for you, but it doesn't avoid probate. So your family is going to have to go through the probate process when you pass away. A notarial will must be executed by a notary, but it doesn't have to be drafted by a notary. So for example, on Willful, we worked with the law firm Spiegel Summer to draft the content of our notarial will, but we have a partner notary who actually executes that will for you and registers it on the Chambre de Notaire, just like if you went to a notary in person. And a notarial will is the only type of will in Quebec that can be executed 100% online. If you choose Willful's $99 plan, the will in front of witnesses, you're going to have to print that document, sign it on paper, have witnesses sign it as well. There's no option for executing that online. Whereas if you choose the notarial plan on Willful, or if you visit a notary to create your will, they can actually execute it completely digitally, register it online with the Chambre de Notaire, no paper required, which is pretty cool. And that was a direct response to COVID. So we've talked a little bit about the Willful platform and our story. We've talked about the 4 different ways that you can choose to create your will in Quebec, as well as what a notarial will is in Quebec, which is a really unique product that you only have in this province. Now let's get into the 3 steps to actually completing your will. So once you've actually decided on the method that you'd like to go with for creating your will, what do you actually need to know before you sit down to do it? Well, there are really just 3 simple steps. The first step is choosing your liquidator. And I often say that choosing a liquidator can sometimes feel like people are choosing a bridesmaid for their wedding. It becomes a popularity contest, and it becomes more about not hurting anyone's feelings and making sure people feel included, instead of choosing a liquidator based on what the role actually entails. So let's go into what's involved with actually choosing a liquidator. So first, what is a liquidator? Well, a liquidator is called an executor in other provinces, so you might be familiar with that terminology. And they're the person who actually executes the wishes in your will and handles estate administration. They're the person responsible, and they have the legal right to wrap up your life and handle your affairs. So they're going to handle your funeral and burial wishes. They're going to compile a list of all of your assets. They're going to close up your accounts. They're going to pay off any of your debts and file your final tax return. Because yes, unfortunately, your debts don't disappear when you pass away, and you still have to pay taxes once you've passed away. They're going to distribute all of the assets to your legatees, to your beneficiaries, and stay in contact with them over time to keep them abreast of what's going on. I mean, this is a really big job. And so, it takes typically about 12 to 18 months, even if you have a simple situation. So when you're thinking about who you want to choose in this role, you really don't want to necessarily treat it as a popularity contest. You want to be thinking about who is really organized, who has the capacity to take this on, and who do you actually think would say yes? Because, not a lot of people want to necessarily act in this role. In terms of who it can be, you can appoint any individual in your life, from a spouse, a family member, or a friend, or you can appoint a professional. So let's say that you don't have anybody who comes to mind who could do this role. You can actually appoint a lawyer, a professional liquidator, or a trust company or financial institution to act in this role on your behalf. The key is really to talk to the person first. You do not have to accept an appointment as liquidator. So if you've been named a liquidator in someone's will and you don't want to do it, you can just say no. And then it would fall to the backups. So it's really key when you're creating your will to ask the person first to make sure that they're okay with it, as well as to appoint backup liquidators in case that primary person is unable to do it. I also wanted to point out that I often get asked about what happens if you have a liquidator outside of Canada. So if you have a liquidator in another province, they may sometimes be asked to post a bond against the estate. We have an article about this in Willful's Learn Center that you can read more about if you do have a liquidator in another province. But if you're appointing a liquidator outside of Canada, that can have major tax implications because it changes the location of your estate from Quebec to whatever that country is. So if you are choosing an out-of-country liquidator, you may want to speak with a tax specialist to understand the implications of that. So after you've chosen your liquidator, it's time to choose your legatees. These are called beneficiaries, so you might be familiar with that terminology from other provinces. And essentially, your legatees are the people who are going to get your stuff. They're going to get your assets and your belongings, whether those are of value or whether they're just heirlooms that have sentimental value. And dividing up your estate can sometimes feel like the movie Knives Out. There are lots of dramatic movies and stories that we've heard in the news about what happens when, families argue over who gets what. But ultimately, you need to remember it's really up to you how you distribute your estate and who you want to make sure gets your assets. You do have an obligation, though, to support spouses and any dependent children. So just keep that in mind. If you are looking to disinherit someone from your will, especially if they're a spouse or a child, you should definitely consider seeking legal advice because you'll want to write some of that reasoning into the will. A recent example of a bit of estate drama came out of Toronto. The head of the Scholastic Book Company passed away, and instead of leaving his sizable fortune to his 2 adult children, his ex-wife, or his siblings, he left everything to the head of strategy at Scholastic, a woman that he was rumored to have a long-time relationship with. And so again, this is an example of, having a will means that you can make sure that your assets go where you want them to go instead of defaulting to family members. Before we get into how you can leave a gift in your will, I want to cover what's not covered by your will. So a lot of times people will say, well, do I need to list my house in my will? And the answer is, only if it's not jointly owned. So there are certain things that don't fall under your will that are not covered by your will. Those things include joint bank accounts. So if my husband and I have a joint bank account together and one of us passes away, the account is already in the other person's name, so it wouldn't need to be covered by my will. Same with any joint investments or jointly owned property. There are multiple ways to own property in Canada, and one of those is jointly with rights of survivorship. That means that if my husband and I own a house together and I pass away, it automatically transfers to him. It does not flow through my will. Same with any pensions that have a named successor on them, or a life insurance policy that has a beneficiary named directly on the policy. Now, in other provinces in Canada, if you have an RRSP or a TFSA or any other registered savings account, you can actually appoint a beneficiary directly on those accounts. In Quebec, you can't. In Quebec, you have to actually leave those as a specific legacy, a specific gift in your will. So we do have some guidance on that in our platform, but just an FYI that's unique to Quebec. So everything else falls under what's called your umbrella estate. We get asked all the time, why don't I have to list out all of my assets, everything that I own, when I'm creating my will on Willful? And the answer is very simple. Number one, you don't want to list out all of your assets in your will because those change often. If you switch banks or you get a new car, you'd have to be updating your will all the time. The other reason that typically you don't list out all of your assets in your will is because your will becomes public domain after it goes through the probate process. And you don't necessarily want your family, friends, or that weird second cousin knowing everything you owned at the time of your passing. So definitely something to think about, and just be aware that you don't need to list everything out in your will. It's covered by, it falls under your umbrella estate. You're all good. Excuse me. Water pause. So who can actually be a legatee? Who can you leave things to in your will? Well, you can either leave things to an individual or to an organization like a charity. So on the individual side, this person can live in Canada or anywhere around the world. And wills created in Quebec, in your province, typically cover assets in other countries. It's not something we specialize in at Willful, so you should definitely seek legal advice if you are looking for nuances around international assets. And you can leave things to if you appoint someone as your liquidator or the tutor for any children, it can be the same person. So you can leave things to a legatee who also performs in another role in your will. Let's say you leave something to a minor, like a minor child or a niece or nephew. Those assets would be held in trust and managed by the trustee, who in Willful's case is your liquidator, until the age at which you choose for them to receive their inheritance. So, you don't have to have them receive it when they turn 18. They can receive it when they're 25, and maybe they'd be a little bit more responsible with it. You can also leave things to charity. So this is a really great way to have a positive impact after you're gone. And it also helps to reduce your final tax bill, because just like when you're alive, leaving a gift to charity means that you get a tax receipt. And this actually reduces your final tax bill and means more money ends up in your legatee's pocket. We're proud to say that we've had over 7,000 gifts to charity left in wills on Willful, and only about 1 in 10 Canadians plan to do this. So I definitely encourage you to consider this, although again, it's totally up to you how you decide to split up your estate. So after deciding who can be a legatee, then you have to choose how you're going to leave a gift in your will. So there are 3 ways to distribute assets: a specific legacy, a cash gift, or a percent of your residue. I'm going to go through each of those in detail now. So first is a specific legacy. This is a specific identifiable item left to a specific person. You may have also heard it referred to as a bequest. This could be, for example, jewelry, a car, an heirloom, shares in a company, an engagement ring, whatever you'd like. And in Quebec, this is also where you would leave the contents of any RRSPs or TFSAs or registered savings accounts. Then you have the option to leave a cash gift. This is just a set amount of money or the contents of a bank account or investment account. And again, you can leave that to a person or to an organization or charity. Finally, your third option is to divide up what's left. So basically what happens is, after your liquidator comes in, they're going to, pool together all of your assets. They're going to pay off your debts. They're going to file your final tax return. They're going to pay for any expenses of the estate, like funeral and burial expenses. And then there's going to be this pot of money left. And that's what you're going to divide up by percentage. And it's referred to as the residue. So you're going to divide that up out of 100%, however you'd like. So you could give 100% to your spouse. You could give 1% each to 100 people. It's really up to you. And again, you can leave, as you can see in the image here, you can leave those assets to an individual or to a charity like the Hospital for Sick Children or a charity in your area that you care about. So those are the three ways that you can actually leave gifts in a will and make sure that your assets go to the people that you would want them to. Now, the third step in creating your will is choosing tutors for your minor children and guardians for pets. This step is all about making sure that people that rely on you, people or pets, are taken care of once you're gone. So, having a child is the biggest inflection point that leads people to create their will, because it's really not just about you anymore. It's about taking care of your children. And one of the key things that you can do in a will is appoint a guardian for their care, or a guardian in other provinces. It's known as a tutor in Quebec. And this is the person or couple that would take care of your children if you and the other parent were to pass away. This is easily the most difficult decision that you'd have to make when creating your will, because it causes you to think about what happens if you aren't around anymore, but your child is. But it's one of those really important decisions that can make such a difference when the time comes, if it ever comes. So this only comes into effect if there's no surviving parent. It's typically a family member or a close friend. So with your liquidator, you're probably, going to choose someone organized who's good with finances. With a tutor, you're picking the person that you think would give your child the best upbringing. You can have a tutor outside Canada, and you can work with a lawyer or notary to draft a will that adds in the reason for that, so that if there's a family court or judge who's looking at it at the appointment, they have some understanding as to why you would want your child to move outside of Canada. As I mentioned earlier, if you do leave money to a minor, like a child, their inheritance would be held in trust and managed by your liquidator, who on Willful also acts as the trustee for any trusts until the age you specify. You don't need to leave money in your will to the tutors for the care of the children, because they actually have access to the funds that are held in trust for things like reasonable care, tuition, clothing, etc. But you can choose to leave money to the tutors if you'd like. And one note, if you do have a child with a disability, there is a special vehicle called a Henson Trust that protects their disability payments, and that's not something that Willful handles. So you may want to speak with a lawyer or notary if you do have a child with a disability. And we can't forget our furry friends. So while appointing a guardian or a tutor for children is really important, appointing a guardian for pets is also important. It's one of the actual top reasons that pets end up in shelters, is that their pet parents haven't accounted for who would care for them when they pass away. So on Willful, we help you to appoint a pet guardian who would care for the pet, and we allow you to leave money for their care, because my mom has 2 horses, and those are very expensive animals, and so they require having a bit of money for their ongoing care. So that's really it. Those are the 3 key steps involved with creating your will in Quebec, along with all of the different methods that you can use to actually get that will done. And you might be thinking at this point, okay, I'm at the finish line, but I want to remind you that part of what makes a will legally valid is how you execute that will, not just the process of creating it. So again, there are 2 types of wills in Quebec. One is a will in front of witnesses. This is Willful's $99 plan. And this is the very paper-based type of will in Quebec. It has to be signed on paper. It has to be signed by 2 witnesses who cannot be legatees of the will. And you have to have this witnessing done in person. You can't do it over a Zoom call or a FaceTime. After you've actually gone through and executed that, and if you do use Willful, we give you this handy instructions page that tells you exactly how to do that and also gives you a list of people who are ineligible to be your witnesses. You're going to store that paper copy in a safe place. You're going to tell your liquidator where it's located, and you're going to ensure that your liquidator has access. So if you keep it in a locked safe and your liquidator does not know the safe combination, not very helpful for them when the time comes. So make sure they have access. And then if you are doing a notarial will, it's a little bit different. You don't need to print it out on paper. You just need to make sure that it is executed by a notary. The notary will typically provide a witness, so you don't have to provide your own witnesses. And again, because of COVID rules, it can be executed fully online, so no paper involved. The notary is going to store the original copy and register it with the Chambre de Notaire, the body that governs notaries and has a registry in Quebec. And then after you pass, your family is going to perform a search of the will registry, and they're going to get access to that will. So it's a little bit of a different process with the notarial will, but in both cases, once you've actually created the document itself, you have to either execute it in person with your witnesses, or you have to go to a notary to execute that will. And with Willful, we help you get right to the finish line in both cases. So congrats, you have now completed your will, hypothetically. So when do you actually keep it updated? So I mentioned earlier that, creating a will isn't a set it and forget it process. Traditionally it has been, people create a will, they put it in a filing cabinet and they don't think about it for 30 years. But you really want to make sure that you're keeping that document up to date and that it's a living, breathing plan that reflects your current life situation. So how do you actually, or when should you actually update your will? Here are a few of the life moments that might cause you to want to update your will. You have a child or another child. You get married or divorced, and that includes entering a common law marriage, as I mentioned earlier. You move to a new province where there's different estate law legislation. You add a new specific legacy. Let's say, for example, you get a motorcycle and you want to leave that motorcycle to your brother. Well, you have to add it to the will. If you want to change any of your key roles or backups, let's say you change your mind on who would be the tutors of your children and you need to switch them up. Or maybe someone named in the will passes away, like you left something to a legatee, they've now passed away and you want to add someone else instead. So there's a couple ways to update your will. So you can either update that will with the original lawyer or notary who created it. They're going to typically create what's called a codicil, which is an add-on. But no lawyer or notary is going to update a will created by a different lawyer or notary because they have liability for those documents. So if you don't want to go back to that original lawyer or notary, then essentially you're just going to execute a new will that revokes the previous version. So on Willful, for example, let's say you had a will that you created 20 years ago with a lawyer and you now want to create it with Willful, you would just go through the Willful process and you would execute that new will and it would automatically revoke the previous version. You would destroy the old will and now you would store the most current version. Updates are free at any time on Willful, which is a really appealing and cost-effective part of the platform. If you do choose the notarial will and you want to make changes, you would just incur the cost of re-executing and registering that with the notary because there are hard costs associated with the registration and with the notary's time. When you do make an update to your will, you do have to print and sign it correctly. If you're going with the $99 plan on Willful with that will in front of witnesses, if you're going with the notarial plan, then you would do that update process directly with the notary to re-execute it, but you can make the changes for free anytime in your Willful account. So you're saving the money on the hourly rate for that notary to actually make those changes. And again, at the time you execute a new will, it automatically revokes the previous version, so you don't have to worry about that. So one final word before I say thank you very much for listening today and send you on your way to complete your will. If you're wondering, what makes my situation complex where I might not be able to use willful and I might have to go to a lawyer or a notary instead. Well, here are a few things. So if you're a business owner, there's something called a dual will that separates your business interests from your personal interests, really for tax purposes. That's something that we don't cater to on willful. If you need a complex trust beyond just a trust for a minor, maybe it's a spousal trust or a Henson trust for a child with a disability. We don't cater to those at willful. Let's say you have property or assets in other countries, like you have a holiday home in Spain. It's possible to have a will in that country that governs those assets and a will in Quebec that covers your assets here. We don't handle the creation of multiple wills at this time. And finally, we don't handle tax advice or legal advice. So you would need to work with a tax specialist or a lawyer or notary if you wanted custom legal advice for your situation. If you're not sure about what makes your situation complex, you can reach out to our customer service team. We're going to be the first people to point you in the right direction, and we can always refer you to a partner lawyer or notary if needed. So thank you very much. I have some placeholders here for a promo code, but the thing to remember there is to email us at support@willful.co if you have any questions at all. We hope you'll consider using Willful to create your legal will in Quebec. But either way, we hope that we empowered you with the information today that can help you to get your will done, regardless of which method you choose. Thank you so much for listening.